Hi, welcome back to Morbid Sunshine. I thought I'd complete today the complaint put forward to the court from the defence of Puff Daddy, aka Sean Combs. We got up to page 18 on the last time. I'm sorry I didn't drop it yesterday, but I don't get many views. I'm not going to do that. I'm not just going to rush to do it. Please like and subscribe, because the more you do, the more I'm going to post, yeah? But anyway, I thought we'll go to... look at all the data I'm giving out, and I'm not getting any subscribers. And I don't know if this is YouTube trying to create a narrative, or people are putting so much narrative out there that mine's getting overclouded, Well, what happens there is that people don't get the full information. I haven't put anything up. I put about Asia up, Asia English. I mentioned nothing in a complaint, a civil complaint, by the way, that she had all these things happen at the parties. She said she was knocked unconscious and things like that, and which I do believe, but I had to delete one video because after that I stopped getting views, because I said basically that she didn't mention it in that, and I'm not sure if that's the truth or what, but I was shocked on the podcasts, and the fact that she was smoking and drinking isn't a good thing for a victim to do, because it looks like you are not taking it seriously, for a start, and with that comes people thinking that that's normal, and I don't know why Adria said the thing she did, but maybe some of that did happen. Maybe she couldn't just put it in a statement to the police because she was incriminating herself in certain aspects. But as I'm trying to put forward here is just the documentation and truth. If you're into the truth, then subscribe. I'm not going to interview people and stuff like that. I'm not sure what my channel's going to come to, what type of business we're into yet, but what my channel isn't about is creating fake narratives out there. And also, please stop reporting me for having music in the background. I sit all day with music on, and I'm not going to change that because someone has a problem with me listening to music in the background when I'm reading these things, because they are difficult to read, and I do need something to boost me. And I'm not sure why people report me for this stuff. I'm not doing anything wrong, so stop. It's getting me flagged a lot, but it isn't even loud enough. I don't know how people heard it, but anyway, I have to take videos down all the time because people trying to strike me for something that I'm not doing. I was only telling the truth. I'm only telling the truth about human, and I do think it's related to dark web activity, like the Diddy and Cassie freak-offs, So we carry on from page 19, because we finished 18. He did that prior to the box sweep. Basically, what we got up to, I'll explain a bit, is that Diddy's solicitor lawyer is saying that this investigator is in a private organisation that they're not known about. They're not working for the MDC. He's working for someone else. He crossed the line, taking photographs of his notes. Even looking at his notes is against the rules. And I'm not sure if this is a ploy to try and get the case thrown out, but if something like that did happen, you can't blame the solicitor for trying to get this thrown out. That's his job. But I have a feeling that it did happen, But I feel that I think the feds are involved in everything, love. I'm not going to lie. I don't trust, this is why, I don't trust the little views I get, because that's telling me that there's something more darker going on. Okay, so that's what happened. And these were notes that he was writing about for a solicitor to investigate and to put forward on his case. So I'm not sure why the investigator felt privy to show the prosecution this. It could have been dealt with in trial, and I'm not sure why the prosecution team had their hands on this. And they did have their hands on it because we had that report on the 19th of November about the notes and about the emergency room meeting. Do you remember that? Anyway, we're up to page 19. He did that prior to the box sweep and acted with a purpose during the sweep, which was why he immediately voluntarily alerted the prosecutors that he photographed materials written by the defendants, including notes regarding finding dirt on witnesses. Moreover, upon being alerted of Investigator 1's conduct, the prosecutors immediately ratified it by debriefing him about the contents of the notes and asking him to produce them, even if they did not order the search ex parte. Then endorsed Investigator 1's unlawful conduct and used it to further their investigation and detention of Mr. Combs. 3. Discovery and a hearing are required. Mr. Combs' rights were violated. As explained below, the appropriate remedy depends on the government's intent, Investigator 1's motivations, and the extent to which the privileged materials have been used to develop the government's investigation. A hearing is necessary to determine these issues and to resolve dispute factual issues. For example, the court claims its review need only be reasonable, not perfect, and says it proceeded in good faith. Docket 72 at 5. But that claim is belied by its insistence, as least prior to the court's intervention, on continuing to use the materials to advance its investigation and prosecution. Hello, kitty. Just give me cat a stroke, hang on. Yeah, you are a beautiful kitty. Anyway, the government account was what happened conflicts with basic information, and defence has learned a hearing is required to find out what really happened and why. The court should not just accept the government's say-so, especially because the government's narrative does not ring true. Moreover, while the government says it didn't specifically direct Investigator 1's to search Mr. Combs' notes in advance of the raid, its conduct after he alerted them to the material suggested this could simply be part of an effort to distance the prosecutors from conduct they knew they couldn't legally participate in. As the court noted, it is possible Investigator 1 thought of himself as an agent of the prosecution team. If so, why? Is that because the history of their prior communications about the government's continued investigation was their tacit understanding that he should do what he could to help the government develop evidence against Mr. Combs at any opportunity. It doesn't explain very well here, but this is talking about Investigators 1's reasons, basically. Who is Investigator 1 and whose instructions was he following? The court should order the government to produce Investigator 1's communications with the prosecutors. Take his testimony to fully understand what he was thinking during the search and explore whether the box sweep served as pretext for his targeted search of Mr. Combs' materials. Now listen, when Epstein, I'm not going to say he unalived himself, was found dead anyway, in a cell, right, we don't know who did that. Now, I think there's a private firm or a private CIA circuit, right, that did that and made sure that happened, because there's a bigger fish to catch. Okay, than Combs, than Epstein, than Ghislaine. It's bigger than that. Okay? And if people think that it stops with Combs and Jay-Z, you're kidding. You're kidding yourselves. It's wrong to assume that Combs is guilty of conduct that we've been talking about. You know, he's been guilty of racketeering and things of that nature as part of his own enterprise for a corporate purpose. Do you understand what I mean? So he's doing this. It's funny how people, listen, it's funny how these people who are just talk show hosts end up with billions in the bank, private aeroplanes and stuff like that, when people with real talents are on the bones, you know? I just don't get it. There's something amiss here. And I think Diddy is expecting his demise, so he's paranoid to fuck, and rightly so, that this person could be trying to guarantee his silence. Now, I want Diddy to talk. I want Diddy to tell us everything. And I think it means we need to protect him. I am disgusting as it sounds. People want him dead, fine. But as a Christian, you need to, and he says he is, you need to confess your darkest moments. And if he did, it would be seen more of a martyr, wouldn't he? So that's what they're going to try and do and target. At the same time, we've got to accept that Diddy was doing this for somebody else. Diddy was doing this. Yeah, he was a sex pest, but he was doing this for somebody in particular, and we haven't found out who that is yet. You know, I'm looking into it, but I'm into reading a lot of civil cases about Jay-Z. I look into Denzel Washington's son and all that, but I won't put it up in case it's absolutely critical, yeah? Because it could, like, come across like I'm targeting, but really what I'm after is the truth, and to put an end to improper conduct, the end to death of children, the end to death of young ladies, the end to the list, because we shouldn't be making money off vulnerability and exploiting it. I think I found doing this, that a lot of people who watch this, we are a minority who subscribe here. We are a minority who want answers and don't believe everything that everyone's saying. And that is a terrifyingly tiny group. It is. There's not many people out there who will read the whole docket. You know why? Because they want to carry this narrative that Diddy's bad, it's just him. No. We need more answers. You want answers? Deep dive, you know? And this means investigating things like this, questioning why the prosecution have the right to do that. Yeah. That's my point of view anyway. The court should also, let's continue, the court should also order disclosure of any video footage of the search to test whether the government's description of the events is accurate. The court should take testimony of Investigator 1, and whomever else was involved to determine which notes. Now, if this man doesn't come forward and speak, I'm going to be highly suspicious. Where Investigator 1 worked alone, or if others were involved, did Investigator 1 use his personal cell phone to photograph the materials? What did he do with the photographs? Did he send them to anyone? Yeah, of course he did. Was Investigator 1 in contact with anyone from the Department of Homeland Security prior to him photographing the notes? While he was doing so, or afterward, did Investigator 1 ever report the officials supervising the sweep? Yeah, everyone should be listed really, shouldn't they? By name and where they were working from. And people aren't pointing that out. I've just got to look over. Did Investigator 1 ever report the officials supervising the sweep that he was photographing Mr. Combs' notes? Did he provide the photographs of the notes to his supervisors? If this was really part of the established protocol, was would accept that he did? Or did he only provide them to, I'm sorry, my eyes, to the US Attorney's Office? Who at the US Attorney's Office knew that he was giving them photographs of Mr. Combs' notes? Question mark. Who proved this? Question mark. Approved. Sorry, I'm a bloody terrible reader, I know. I'm sorry, guys. And before weighing the prosecutor's claims that they acted reasonably after being alerted, the court should hear testimony and order discovery of any emails, texts, or other communications regarding 1. What exactly the prosecutors knew before requesting copies of the notes. 2. Whether any context was communicated to the filter team before the filter team conducted its review of the notes. So the filter team should have filtered the notes to make the claim that they did on the court date that they wanted that emergency meeting. Now, really, they didn't disclose the notes, so we don't know exactly what the prosecution saw of those notes, yeah? Why the notes were not shared with the defence team in accordance with the filter team protocol. Now that's odd. And FEDR Crime P 16 and 5. Who else the government shared the notes with, including possible witnesses or alleged victims? This is all critical to assessing the government's intent. It really is. A hearing is particularly necessary because the government's description of the events does not align with the defence's team understanding what transpired. As explained, it is not clear who Investigator 1 is or why he was participating in MDC sweep. The government's representation of Investigator 1's encountered the notes on Mr. Combs' bunk, and that there was no indication the notes were privileged is in dispute. And the court should more fully understand what exactly Investigator 1 reviewed, not merely what he photographed, given that he remains enmeshed in government's ongoing investigation, but has been given a preview into the defence strategy, which is wrong. I know. It's really, really messy. United States versus Arrington is instructive in 2022. There, the defendant argued his rights were violated during a similar search in the prison cell. The court ordered the hearing complete with testimony from agents included in the search concerning a chain of custody of the papers taken from defendant's cell and concerns regarding review of privileged attorney-client communications and defendant's work product. The government voluntarily produced video footage of the search before the hearing, which the court considered in weighing the testimony. In United States versus Arrington, Arrington is not unique in requiring a hearing. Conducting hearing because full factual record was required to resolve the motion. In United States versus Lange, in 2001, requiring testimony at Castig hearing. Oh, they're naming all these things. These court places these court hearings that have had this happen before, and what's the outcome and what they did. Remanded for hearing on whether government agents deliberately intercepted telephone consultations between the defendant and a lawyer before the trial. This is talking as an example. The court, now we're on to the second paragraph. The court must also assess whether the government's investigation itself and the prosecutors have been tainted by the unlawful search. Defendants may request a hearing to determine whether information derived from the privileged sources was used by the government in violation of attorney-client privilege to prepare for trial. In this case, Schwimmer v. United States, the district court should have conducted an evidentiary hearing to determine whether the government's case was in any respect derived from a violation of attorney-client privilege. In Cohen case, the court should consider what fruits, if any, were obtained from the information seized. And the government has likely already made affirmative use of the notes, even apart from their use in government's bail arguments. So basically, this unfairness has led to him not having bail, you know. A hearing is required to learn 1. The extent of which the prosecution team used the privilege notes to develop leads or uncover new evidence. 2. What other information prosecution team learned from investigator 1, and whether the information led to prosecution team to develop new leads or gather new evidence. 3. What other information investigator 1 learned, and whether investigator 1 used any privileged information to develop new leads or gather new evidence. And 5. Whether the privileged information was conveyed to anyone else, and whether any other government agent used the information to develop new leads or gather new evidence. 4. This court should order appropriate remedies. A. Use and fruits suppression. Even without further fact-finding, it is clear that the government violated Mr. Cohen's 4th, 6th amendments. Okay, so he didn't obviously violate the 5th. The government conceded that if the notes are indeed privileged, the immediate remedy would be to suppress the government's use of those notes. In November 19th, that is true. Indisputably, when the government obtains access to defendants' documents, the government is not entitled to rely on privileged materials contained therein. See this case to support. To the extent that the files obtained were privileged, and the remedy is suppression and return of the documents in question. So they're trying to suppress what they did and what notes were given, and trying to move it along like nothing's happened, basically. It is clear the notes are privileged, were the product of an unlawful search, and must be suppressed. Well, you know, must be not added to the prosecution's evidence. But the government also suggested that it could continue to use the contents of those notes in its ongoing investigation. Now, why is that? You know, this is the important thing. I'm going to have a look into this and post more on maybe what the prosecution are going to reply to this. The government also suggested that it could continue the use of the contents for those notes in its ongoing investigation. It refused to disclaim reliance on the substance of what it learned from the legal search. In November 19th, the government thus took the position that while the notes themselves could not be used against Mr. Cohen, it could continue to use the fruits of the search against him, which is wrong, which is possibly wrong, because we don't know what was in the notes or what was written, okay? It could be something really dangerous, you know. That is wrong as a matter of well-settled law. A violation of the 4th Amendment requires suppression not only of the immediate object of the search, but also any other evidence obtained because of the search. In other words, the exclusionary rule applies not only to the direct product of unconstitutional invasion of the defendant's 4th Amendment rights, but also to the indirect or deprivative fruits of those invasions. In other words, it doesn't matter what's in the notes. What is true of the 4th Amendment violations is also true of the 6th Amendment violation. When the government interferes with defendant's attorney-client privilege, it must take care to refrain from affirmatively making use of the interference. The government must follow the procedures set forth. It must demonstrate that the evidence it uses to prosecute an individual was derived from legitimate, independent sources. Applying Castiga's framework and holding that government must prove its evidence was not tainted by the privilege violation and was derived from a legitimate, independent source. Thus, it is not enough to suppress the notes themselves. All fruits of illegal intrusion must also be suppressed, and the government has an ongoing obligation to demonstrate that it made no use of the information obtained by illegal search. The government cannot, for example, use the information obtained from the notes to seek additional charges against Mr. Combs or conduct additional searches. Evidence seized during the illegal search should not be included in a warrant affidavit. It is troubling that the government has already suggested it may do so. It is troubling because there's no explanation. There's no. If he did do that illegal search or did that search, what was the intent of it? What was the intent? If not to obtain defendant's strategy. It sounds corrupt to me. B. Appointment of a special master. Yeah. The court should also bar further use of the inherently flawed taint team procedure. It should instead appoint a special master to resolve privileged issues. The government noted it at the hearing that several district courts in this circuit have approved the taint team procedure. That is true. What the government failed to note is that the growing number of courts around the country have rejected the procedure for the simple reason that the government lawyers have proven they cannot be trusted to protect the criminal defendant's privileges. As the Sixth Circuit has held, taint teams present inevitable and reasonable foreseeable risks to privilege, for they have been implicated in the past in leaks of confidential information information to prosecutors, Well, they have, haven't they? While a taint team may have an interest in protecting privileges, it also possesses a conflicting interest in pursuing the investigation. And human nature being what it is, occasionally some taint team attorneys will make mistakes or violate their ethical obligations, i.e. the procedure has insufficient checks to correct the government mistakes, whether honest or otherwise. In short, under a taint team procedure, the government's fox has left in charge of the defendant's henhouse. Interesting way of putting it. And may by neglect or malice, as well as by honest differences of opinion. The Sixth Circuit thus ordered the District Court to employ a neutral special master instead. Other courts have similarly noted that the taint teams are inherently insufficient to protect the defendant's rights. The Fourth Circuit has held, for example, that when a dispute arises as to whether the lawyer's communications or a lawyer's documents are protected by the attorney-client privilege or work product doctrine, the resolution of that dispute is a judicial function. That function cannot be delegated to the executive branch. Like the Sixth Circuit and the Fourth noted that it is highly problematic to allow other prosecutors to make determinations about the adversary's right to privilege, citing recent blunders. It included federal agents and prosecutors rummaging through materials that are protected by attorney-client privilege, and the work product doctrine is at odds with the appearance of justice. More recently, the Fifth Circuit noted that the government's use of the taint team had resulted in a callous disregard of the criminal defence rights. Puts another case forward. The privileged material was obtained through a valid search. This is talking about another investigation. A valid search warrant did not justify the government's conduct, nor did the existence of secret ongoing grand jury proceedings. The Fifth Circuit held that all potential privileged material must be immediately returned, that is, not held by a filter team, and that going forward the district court should engage a magistrate judge or a special master to review the potential privileged documents. Many district courts around the country have likewise questioned the taint team procedure. District courts in this circuit have previously expressed similar misgivings in other cases. The cases above recognise that, in general, the use of neutral arbiter, such as a special master, is more likely to protect the defendant's rights than to use of a prosecutorial taint team. And whatever the general merits of the taint team procedure, the filter team in this case utterly failed, despite seeing references to defence experts, paralegals, witnesses and cross-examination strategy, and even names the defence lawyers. It failed to mark the material as privileged. It is inconceivable that a taint team attorney identified obviously privileged communications on a page, marked it as such, and yet did not recognise the remainder of the page referencing lawyers and paralegals as also privileged. The taint team have proven itself to be completely incapable of performing the most basic privilege review. Moreover, where the court has approved the use of the taint teams, the government typically seeks court pre-approval of its filter team protocol in an adversary context or in an informal good faith resolution with the defendant. In this case, however, the government neither saw court pre-approval of its filter team protocol in an adversarial setting nor engaged in good faith informal negotiations with the defendants about the creation of the protocol. To the contrary, the government simply created its own rules, did on this occasion, departing from the parties' previous practice and understanding. There's a lot of P's in this, isn't there? Predictably, the result was a disaster. The filter team handed over obviously privileged material to the case team in barely redacted form. In other words, this is not the case where the filter team did its work carefully and thus successfully hid privileged materials from the case team. Prosecutors successfully screened. This is an example of the case and what happened. Screened the privileged material. The FBI agents did not communicate anything from the defendant's papers to the prosecution team. So in this case he's referencing to that didn't even happen. So even to that extent, the absolute grandiose of this and the audacity of it is obvious to me. The filter team failed to do its job and violated Mr. Combs' rights. There is no reason to think it will do better going forward, or that the case team will call its fouls when its errors again. This court should appoint a special master. See dismissal of the indictment. That's pushing it. I doubt you get that, mate, but nice try. Based on the information already known, it is clear that the government has violated the Sixth Amendment by introducing on the attorney-client relationship and interfering with Mr. Combs' relationship with counsel and his ability to mount the best defence he can muster. This extraordinary violation of Mr. Combs' Fourth and Sixth Amendment rights also constitutes outrageous government conduct that violates his Fifth Amendment rights to due process. Dismissal of the indictment may therefore be warranted upon the development of the full factual record at the hearing. Dismissal is appropriate not only where the conduct of the government has been manifestly and avowedly corrupt, but even where the conduct merely involves intentional intrusion into attorney-client domain, resulting in prejudice to the defendant's case. For example, in the staying, the Second Circuit affirmed the dismissal of the indictment against numerous defendants charged with major tax evasion. This is talking about a certain case scheme, because the government had interfered with their ability to retain counsel of their own choice. Okay. The court affirmed Judge Kaplan's ruling that no other remedy would restore them to the position they would have enjoyed but for the government's unconstitutional conduct. Moreover, even as to some defendants who were not deprived of their chosen counsel, the remedy was appropriate because the government had interfered in their relationships with the council and impairment of their ability to mount a defence, including by impeding the scope of their pre-trial investigation and preparation. Staying supports dismissal here, even though the government misconduct has taken a different form in this case. It's confusing because he's talking about another case and what happened, but he goes on to say, the constitutional surveillance of Mr. Combs notes about the preparation of his defence and privileged communications with his counsel have interfered with counsel's ability to provide effective assistance, just as the unconstitutional interference with counsel's fees did in the Staying case. Here, for example, though, we do not yet know the full extent of which the prosecutors have used the privileged information. They cannot unlearn the preview defence strategy. In other words, they've seen what they've seen, that's that now. You can't go back on that, can you really? You know. They have obtained, nor can any other violative use of the privileged information be undone at this point. Specifically, the government already admits it has 1. Listened to Mr. Combs' calls, including with family members and his attorneys, and 2. Reviewed his messages, including with dozens of individuals, including attorneys. And as is clear from the government's reliance on Investigator 1 and its bail arguments, the government has not hesitated before affirmatively deploying Mr. Combs' privileged communications against him. That constitutes as a violative use of the privileged information. It makes matters worse. The communications at issue clearly gave the government a preview of defence strategy. The problem in this case, however, is not that the government obtained incriminating statements. He's talking about the Schwimmer case. Incriminating statements or other specific evidence, but rather it obtained information about Danielson's trial strategy. The notes reference strategy: 1. To discredit particular allegations and corresponding witness testimony. 2. To obtain a specific type of expert witness for trial. And 3. Collect cross-examination material on the particular witnesses. Thus, the prejudice of Mr. Combs' defence is clear, and dismissal could be appropriate. It remains to be seen whether the government put Mr. Combs' privileged information before the grand jury or made other use of the information, but notably the government has never denied such, nor has it disclaimed any intent to use the notes in the future. To the contrary, it stated it would shy away from any suggestion that we put them in a vault and lock them up. D. Disqualification and other potential remedies. Depending in part on the particular nature and extent of the violation uncovered at the evidentiary hearing, the court should also consider whether the remedies are appropriate. For instance, if the court determines that dismissal is not warranted because a lesser remedy can cure the violation, this court should consider whether any members of the case team have been tainted in a way that warrants disqualification. This court has the power to disqualify individual government attorneys where circumstances warrant it. And I think should be the case, really. If an individual attorney engaged in misconduct or is irredeemably tainted by access to privileged material or its fruits, that attorney should be disqualified. The court should also consider office-wide disqualification if the evidence adduced at the hearing warrants such disqualification. Additionally, this court should order the government to stop monitoring Mr. Combs' communications with his attorneys immediately. Federal law allows monitoring of attorney-client communications only in limited, extraordinary circumstances involving terrorism and the like. There is no legal basis for the government's monitoring of Mr. Combs' privileged communications in this case. Moreover, the government's conduct to date makes clear it cannot be trusted to respect the privilege or Mr. Combs' constitutional rights. The conclusion is, for the foregoing reasons, the court should order discovery and hold a hearing, and should further order other necessary relief, including but not limited to 1. Suppression of the notes and any fruits of illegal search. 2. Directing that the Special Master conduct privilege review in lieu of the filter team. So he wants the Special Master to review before the filter team going forward, before anything's passed forward. 3. Disqualification of any and all prosecutors tainted by access to the privileged materials, which means fire the people who were involved, 4th, ordering the government to stop monitoring Mr. Combs' communications with defence team. And 5, depending on the evidence adduced at the hearing, dismissal of the indictments. Respectfully submitted on December 4, 2024 by Shapiro. And that's all for now. Part 1 is in my and that's called, it's listed under Mr. Combs' 4th, 5th Amendment rights being violation. That's what the title is. So if you want to look and have a look at that and go through it yourself, it'll be a 2-hour reading session, I know, but to get a better understanding of what's going on here, I think it's definitely worth listening to what I'm saying, to listen to what be objective, because we know there's more to this than meets the eye. And subscribe for more, please. I'm struggling to get subscribers. I need more. I need to get my word out there, the truth out there, and to be objective and to look into this in a clear, dignified way for the victims and the defence. And God bless you all. Take care for now. Lots of love. Bye-bye.